So, peace and love, peace and love. Welcome, brother Isaiah. Yeah, with another for all my conscious brothers and all of my conscious sisters in the conscious community. Keeping the struggle because we know that it's through the struggle that we grow. Also, I'd like to say that it is in fact a slow process with progress that the race is never will. But to those that remain beautiful, so make sure you stay in this for the long haul. Y'all already know I don't offer legal advice, not a legal counsel, an attorney, or any of those titles. I am your brother, and I am sharing with you education and information about my walk, about my travels, about my journey called life. And I like to extend these honors to you. Because when you're honoring man, you're honoring woman, you're honoring yourself. Thank you, adoration to God that did live my life and extend the same love, courtesy, and acknowledgement all of his messages and prophets. You, beloved brothers and sisters, and ride for all those that are awakening in this day and time. Peace to you, brother. So today, I decided that I wanted to go over information. I wanted to go over some information pertaining to judiciary conduct and what's required, like when you dealing with a judge, like we got to really learn what our rights are, and it's only each one teach one is what I believe. I believe that as a brother to another or whatever, we should help one another with comprehension and understanding. A lot of people or a lot of these legal agencies and stuff like that, they don't want you to know certain things because then it makes it easier for them to take advantage of you or do the things that they do and not be liable for any misconduct or anything that they do that is incorrect. So, usually when we have our run-ins, most of the time it's in the judicial system and we're dealing with judges and different things like that. And most of the time when you go into a courtroom, it almost feels, at least it's my experience from a personal experience from myself, it almost feels as if the judge or the magistrate is working for the prosecutor, in a sense that they got something going on, and when you come in, it's already preset, and the judge is already trying to seal the deal, sort of kind of like, because if they can get you to accept responsibility, then everything is a go. So it's like when you come in, it's supposed to be impartial, it's supposed to be fair, you're supposed to hear the facts. And if it's jurisdictional matters and other matters that need to be dealt with before the proceedings, then all these things have to be adhered to or dealt with before they start doing certain things, and it's a lot of things that they do that's not correct. All right, so this is the preamble and the scope to the code of judicial conduct, right? And it says that an independent and fair and impartial judiciary is indispensable to our system of justice. And the United States legal system is based upon the principles that an independent, impartial, and competent judiciary composed of judges with integrity will interpret and apply the law. Thus, the judiciary plays a central role in preserving justice and the rule of law inherent and the rules contained in the codes of judicial conduct code, right? Are the precepts that judges individually and collectively must respect and honor the judicial office as a public trust. So when they sitting at that seat, y'all, they're sitting in a seat of trust. So when you come in, it's only fair that you acknowledge that you are the beneficiary of the trust, or you are the, you know what I'm saying, a personal representative or trustee. It all depends on how you want to operate. But most people come in and they express the trust because the judicial office is a public trust. That's what it is. So when you come and you're dealing with any office of the judiciary, you're dealing with a public trust, and strive to maintain enhanced confidence in the legal system. All right. And it makes sense that it's a seat of trust because they're entrusted with the, people's livelihoods, people's financial records, and you got to be a fair person to sit in those kind of seats when you making decisions, and people are going doing time for. So if you're dealing with a crooked judge or a judicial officer that's impaired and not fair and showing impropriety, that man, you know, it says judges should maintain the dignity of judicial office and avoid both impropriety and the appearance of impropriety in their professional and personal lives. They should aspire at all times to that conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. So when we deal with these judges, we should feel that we're dealing with a person of a high respected standard that has to, wear a certain type of conduct in order for you to even feel that he's a fair person. If he's yelling at you, screaming at you, and the prosecutor just sitting there, that definitely is not fair. That's definitely not impartial. It's a lot of things that we know. This word impropriety, right? Let's look this word up. Because when you doing stuff like this, you want to know what it means. So impropriety refers to the behavior that is dishonest, okay? Social unacceptable, socially unacceptable, unethical, or otherwise unsuitable for a particular situation or position of responsibility. It can refer to an isolated action or a general state of being improper, like, so what I'm trying to show you is that, all right, they have codes of conduct that they have to follow. And in order for you to know when he's doing something that's if he's showing impropriety, right, in his appearance or his professionalism, you would have to know the codes of conduct. So that's why we're here today. And that's why I'm going over this, because this is something very important for us to understand the judiciary code and what their conduct is supposed to be. Because you can't hold a person responsible to something if you don't know what it is that he's responsible for. So to know their code, just like they know the codes that deal with you as an individual that violated section 212. So what about the sections that he has to abide by, and knowing the codes that govern over what his activities are? So we have to square up, and be able to leverage and hold them accountable for any acts and deeds that they do, being able to assert the right information. Because sometimes we might be coming with USC codes and all these different things, but what I'm learning in my studies is that there's a particular code, law, rule for every department that they must adhere to. And when you find that particular law and you start to enforce that particular law, it really changes the dynamics of how things go. Because now you're coming with something that's, man, listen, this judiciary code is a cold thing right here, man. I'm telling you I ain't gonna give you nothing wrong. This thing is fire, like for real, because you wouldn't know what a judge was supposed to do, right? Check this out. It said the code established standards for ethical conduct of judges and judicial candidates. And the code is intended to guide and assist judges in maintaining the highest standards of judicial and personal conduct and to provide a basis for regulating their conduct through the Illinois Judiciary Inquiry Board and the Illinois Court Commission. So these are two places like where you can file complaints and stuff like that. Go into that at a later time, but this commission, this board that they got, because you know that they are an administrative agency, so they got a board, they got a commission, they got all the things that an agency will have. Right now, the code governs a judicial personal and judicial activities conducted in person, on paper, and by telephone or other electronic means. A violation of the code may occur when a judge uses the internet, including social network sites, to post comments or other materials such as links to websites, articles, or comments authorized by other photographs, cartoons, jokes, or other words or images that convey information or opinion. Violations may occur even if a judge distribution of a communication is restricted to family and friends and is not accessible to the public. Judges must carefully monitor their social media accounts to ensure that no communication can be reasonably interpreted as suggesting a bias or prejudice or aspartate communication that misuse of judicial power or prestige, a violation of restrictions on charitable, financial, or political activities, a comment on pending or impending cases, a basis for disqualification, or an absence of judicial independence, impartiality, integrity, or competence. So so basically they're held to the highest scrutiny. I mean, they can't even have fun like the regular like how we can get on there and just, they can't do all that. They can't get on there and be dancing and popping and they can't, they have to have a certain characteristic that they must maintain at all times according to the code. Okay. So when you start going in and learning about this code, you start realizing like, man, these people are really in violation of a lot of things because we are lacking the knowledge of it, right? The code consists of 4 canons, numbered, ruled under each canon, and comment that generally follow and explain each rule. The policies and the scopes and terminology sections, right? Provided additional guidance in interpreting and applying the code. The number of the code is patterned on American Bar Association Model Code of Judicial Conduct, revising numbers and provisions not incorporated in Illinois. So the way they got it set up, it got the terminology, it got the scope, and it break everything down in sections so that you can understand exactly how the code applies to the judiciary conduct and how they supposed to perform, right? Now it says the canon states principles of judicial ethics that all judges must observe. Although a judge may be disciplined only for violating a rule, the canon provides important guidance in interpreting the rule. Where a rule contains permissive terms such as may or should, or conduct being addressed is committed to a personal and professional discretion of a judge or a candidate in question, and no disciplinary action should be taken for actions or inactions within the bounds of discretion, right? But let me go down. So when you get down to here, this is like the terminologies, right? Where it breaks down, you know, what all the terms mean, like contributions, uh, the minimus, in the content of interest pertaining to disqualification of a judge means insignificant interest that could not raise a reasonable question regarding the judge impartiality, right? Domestic partner. Now, this right here was like, when I read this, this a good one, because this one kind of show you that you in a domestic relationship with a domestic entity that's covering you, but it's not your spouse though, right? So it says means a person with whom another maintains a household, right? So a domestic partner is somebody who maintains a household with another person and an intimate relationship. You see that? Other than the person's legal spouse. So who would that be? You know what I'm saying? If I got a spouse, but you saying that my domestic partner is somebody that I maintain a household with and I have an intimate relationship with, but it's other than my spouse, that's, it make you think like, man. But it could mean in another sense too, meaning that somebody just living with somebody else, but it's not their wife or something like that, or person that they actually, you know, you could be living with somebody other than the person you're supposed to be with. And then they consider that person that you're staying with other than the person that you're with as your domestic partner rather than your spouse or something like that. So it all depends on how you look at it. Economic interest is talking about the ownership of more than a diminished legal or equitable interest, except situations in which a judge participates in the management of such a legal and equitable interest, or the interest could substantially be affected by the outcome of the proceedings before the judge. It does not include an interest in an individual holding within a mutual or common investment fund, an interest in securities held by an educational, religious, charitable, fraternal, or civil organization in which the judge or the judge's spouse, domestic partner, parent, or other child serves as a director, an officer, an advisor, or other participant. A deposit in a financial institution or a deposit or proprietary interest, the judge may maintain as a member of a mutual savings association or a credit union or similar proprietary interest. An interest in the issuer of the government security held by the judge, right? Then it talks about fiduciary includes the relationship such as executor, administrator, trustee, or guardian. And then impartiality means the absence of bias or prejudice in favor of or against particular parties or classes of parties, as well as maintenance of an open mind in considering issues that may come before a judge. And then you got impending matters, impropriety, conduct that violates the code. So it basically, these are just all the definitions, like knowledge, like when a judge come to know a certain fact, like means actual knowledge of a fact in question. So if you question in certain facts and you made it known to the judge, once it becomes known, then it can't say that they didn't know. So now your conduct in accordance to the code must be in compliance. Now, so all this is just dealing with like all the different definitions and what it means. So when you get down here to Canon 1, this is where it actually gets into the code, right? So we can read it a little bit, right? So Canon 1, it says that a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety in all the judge's activities, right? Number one, comment. An independent and honorable judiciary is indispensable for creating and preserving public trust and confidence in the legal system. This code shall construe to apply to further this objective, right? Because how can we believe in a judiciary system if it's corrupted, if we see corruption, right? A judge shall comply with the law, including the code. So it's telling you. So he got to what? He got to comply with the law. So if you put the law before him and you show him that he's in violation or the case is in violation of the law or the code, he got to comply. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. And see, this is what you need to be reading out to him in the courtroom, letting them know that what his judiciary conduct is. Public confidence in judiciary is eroded by improper conduct and conduct that creates the appearance of impropriety. A principle applies to both the professional and personal conduct of a judge. Number two, a judge should expect to be subject of scrutiny that might be viewed as burdensome if applied to other citizens and must accept restrictions imposed by the code. See what I'm saying, man? They are public servants, man. You see what I'm saying? They have to follow certain stuff. So when you learn the judiciary codes of conduct, you can start enforcing these codes along. Because a lot of times when we enforcing our documents and stuff, they be trying to ignore stuff, do stuff. So now you got to come with the code along to enforce the code to show impartiality or anything that he's doing that violates this code, right? It says code conduct that comprises or appears to comprise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary because it is not practical to list all such conduct. The rule is necessary, cast in general terms. Judges should participate in activities to promote ethical conduct among judges and lawyers, support professionalism within the judiciary and the legal profession, and to promote access to justice for all, right? Actual improprieties include violations of the law, court rules, or provisions of this code. The test for appearance of impropriety is whether the conduct will create in a reasonable mind a perception that the judge violated this code or engaged in other conduct that reflects adversely on the judge's honesty, right? Impartiality, temperament, meaning if he got loud, if he's, I'm gonna put you in contempt, you say one more thing and all that, you know, or fitness to serve as a judge. Now I'm questioning whether or not you are really a judge, man. I need to see some credentials now because your conduct is way out of whack, sir. You are held to the highest standard. And you're not showing impartiality right now. You're showing me signs of improprieties, of which is a violation of judiciary code. You see what I'm saying? And when you understand these things, see, they don't expect for you to know that. Well, how many people you think know about judiciary code? Not a lot of people is reading about what a judge is supposed to be doing, right? Now, a judge should initiate and participate in community outreach activities for the purposes of promoting public understanding and of confidence in the administration of justice. In conduct such as activities, the judge must act in a manner consistent with the code, right? Avoiding misuse of prestige of judicial office. A judge should not misuse the prestige of the judicial office to advance the personal or economic interests of a judge or others, or allow others to do so. Then it says improper use. It is improper to use or attempt to use the judge's position to gain personal advantage or differential treatment of any kind. For example, it would be improper to allude to judicial status to gain favor treatment in encounters with traffic officials. Similarly, a judge must not use the judicial title in letterhead, emails, or any other forms of communication, including social media or social networking platforms, to gain an advantage in conducting personal business. Judges may provide a reference or recommendation for an individual basis on the judge's personal knowledge. Judicial stationery may be used for reference and recommendation. Judges may participate in processes of judicial selection, except as otherwise forbidden by restriction by Canon 4. Now we go into Canon 2. It says a judge shall perform the duties of judicial office impartiality, competently, and diligently. Given proceedings to the duties of a judicial office, the duties of a judicial office that's prescribed by law shall take preponderance over all of a judge's personal and extrajudicial activities. Comments to ensure that the judges are available to fulfill their judicial duties. Judges must conduct their personal and extrajudicial activities, including the use of social media or participation on social network platforms to a minimum to minimize the risk of conflict that will result in frequent disqualifications. See Canon 3. So, like, if you know of a judge, they got a social media site and they on there and they doing certain things, but they also over a certain case and stuff, you can disqualify. You could get them disqualified because they are held to the highest scrutiny. They can't do what everybody else do. You see what I'm saying? Although it is not the duty of the judicial office, unless prescribed by law, judges are encouraged to participate in activities that promote public understanding of the confidence in the judicial system. So they're supposed to be in programs that's promoting the confidence of building the judicial trust in the judiciary system. Judges are reminded that Article 4, Section 13, Article 6, Section 13 of the Illinois Constitution of 1970 requires the judge shall devote full time to judicial duties concerning a judge's ability to participate in teaching. So they gotta be like, dang. So, when they say they held to the highest scrutiny, right? Impartiality and fairness. A judge shall uphold and apply the law. It didn't say the code, because when you go in there, they always talk about what, y'all? The code. Well, according to the Illinois statute code section, it said the judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Number 1, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Number 2, although each judge comes to the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regards to whether the judge approves or disapproves of the law in question. 3, good faith, errors of fact or law do not violate this rule. It is not a violation of this rule for a judge to make a reasonable accommodation consistent with the law and court rule to ensure pro se litigants the opportunity to have their matters fairly heard. Okay? Bias, prejudice, and harassment. A judge shall perform his duties of judicial office, including administrative duties, without bias or prejudice. Okay? A judge shall not, in performance of his duties, by word or conduct, manifest bias or prejudice or engage in harassment, including but not limited to bias, prejudice, or harassment based upon race, sex, gender, identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, social economic status, or political affiliation, and shall not permit court staff, court officials, or other subjects to the judge direction and control to do so. Proceeding before the court shall be conducted with manifesting bias and prejudice or engaging in harassment based upon attributes including but not limited to race, sex, gender, identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, social economic status, or political affiliation, by or against the lawyer, parties, witnesses, or others. The restrictions of paragraph B and C do not preclude the judge or a lawyer from making legitimate reference to list factors or similar factors when they are relevant to issues in a proceeding. A judge shall not retaliate against those who report violations of Rule 2.3. All right, because you can report this to their disciplinary board, right? A violation of the Supreme Court rule, non-discrimination, and anti-harassment policy is a violation of this rule. So, see, that's why I read stuff like this because, see, did you know that they had that a non-discrimination and anti-harassment policy? See, when you know that, now you can go look it up, and you can say, okay, oh, they got a. So now, when you start reading the policy, if you see anything within there that they're doing, you can use that, right? A judge who manifests bias or prejudice in proceedings impair the fairness of the proceeding and brings the judiciary into disrupt. Examples of manifestation of bias and prejudice include, but are not limited to, slurs. Like, so when they yell, I told you, like when they yell at you, to slur at you, demeaning nicknames, like, because I know one of them said to me one time, he was like, yeah, he said, what, you must be imbecile. He said some old smart stuff he said out his mouth, right? And then it says negative stereotype, attempted humor based upon stereotypes, threatening, intimidating, or hostile acts suggesting connections between race, ethnicity, or nationality, and crime, and inherently reference to personal characteristics. Even facial expressions and body language can convey a party and a lawyer in a proceeding, junior, the media, and others an appearance of bias or prejudice. The judge must avoid conduct that may reasonably be perceived as prejudice or bias. So he can't even like they've been getting away with a lot of stuff, y'all, because we don't know. And we didn't know. So we didn't know that they weren't supposed to be doing that. Like, you can't even show certain facial expressions that make me believe that you got some kind of bias or prejudice against me based off the fact that I'm not accepting the claim, or I'm not pleading, or I'm expressing some sort of right or claim that I feel that I have in reference to the proceedings at hand, and or I'm denying that a proceeding should be at hand until you provide certain information to me, or anything of that sense. And then you going belligerent on me, yelling at me, screaming, threatening me, saying you're gonna put me in jail, or any of these type of things will be a violation of judiciary conduct, because now you're harassing me, right? Because I won't do a specific thing, or I won't conduct myself in a way that you feel that I should just adhere to, right? So let's just keep going. Harassment is verbal, nonverbal, or physical conduct that degenerates or shows hostility or aversion toward a person based on characteristics or classes identified in paragraph B and C. See? So he can say it out his mouth. He ain't got to even say it. He can just move it. He can move a certain way, look at you a certain way, or just stare at you like he wanna. Anything that you feel that he's trying to intimidate, he's using bias, he's not being fair, any of that, right? Check it out. Harassment based on sex include but not limited to sexual advance, requests for sexual favors, and other verbal or physical conduct of a sexual nature that is unwelcome. Rule 2.5 requires judges to take appropriate actions when they learn of another judge's misconduct. In considering this obligation, judges should recognize that failing to inform court leadership of an incident may allow a pattern of misconduct to go undetected. Judges may have special reporting obligations under the Supreme Court of Illinois' non-discrimination and anti-harassment policy. So you can report one judge to another judge, or to a higher judge, or to an actual district judge, Article 3 judge, about another judge conduct in reference to judiciary code of conduct. And they gotta report that to a higher, or you can just go straight to that judiciary disciplinary board and report it, right, for violations of the code. Ethical influence on judicial conduct. A judge shall not be swayed by public clamors or fear of criticism. A judge shall not permit family, social, political, financial, and other interests and relationships to influence the judge's judicial conduct or judgment. A judge shall not convey or permit others to convey the impression that any person or organization is in position to influence the judge. An independent judiciary requires the judge's decision cases according to the law, in fact, without regards to whether the particular law or litigants are popular or unpopular with the public, media, government officials, or judges, friends, or family. Confidence in the judiciary is eroded if the judicial decision making is perceived to be subject to inappropriate outside influence. All right, so they can't, they really don't have no wiggle room. Once you know certain stuff, you can hold them to the highest standard, right? Competence, diligence, and cooperation. A judge shall perform judicial and administrative duties competently and diligently. A judge shall cooperate with other judges and court officials in administration of court business. Competence and performance of judicial duties requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary to perform judges' responsibilities of judicial office. A judge shall seek the necessary dock time, court staff, and resources to discharge all adjudicative and administrative responsibilities. All right, promote disposition of court business requires a judge to be punctual in attending court and expeditious in determining matters under advertisement, under advisement, and to take reasonable measures to ensure the court officials, litigants, and other lawyers cooperative to achieve cooperate to achieve that end. In disposing of a matter promptly and efficiently, a judge must demonstrate due regard for the rights of parties to be heard and to have issues resolved without unnecessary cost or delay. A judge shall monitor and supervise cases in ways that reduce and eliminate dilatory practices, avoidable delays, and unnecessary costs. All right, now this is one of the most important parts right here because a lot of times they don't want to let you be heard, right? He must ensure the right to be heard. A judge shall accord to every person who has a legal interest in the proceedings or that person's lawyer the right to be heard according to law. So the court already know that you have an interest in the case. And according to the Uniform Commercial Code, security interest is what secures your rights and everything. So you already got an interest. Maybe you're not claiming it, but you already accorded an interested party. That's why they're calling you an interested party and bringing you in because you are a party who holds an interest in the proceedings, right? And the judge may accord parties to a proceeding and their lawyers to settle matters and disputes, but the judge shall not act in a manner that coerces any party. So when we go to court, the judge ain't supposed to be coercing you to take no plea. He ain't supposed to be involved between me and the prosecutor. So whatever me and the prosecutor got going on, if we can't come to a reasonable understanding and an agreement pertaining to the matters at hand, then we have a formal disagreement. Judge's supposed to be listening to the facts and trying to resolve the matter between the parties to come to a resolve, not forcing you to plead, not forcing you to go to trial, not forcing you to move forward when you have an issue pertaining to the matter at hand, all right? Or coercing you, telling you, are you going to accept the plea or are you not? If you're not, I'm going to put a plea in for you. When they do stuff like that, they're not ensuring your rights to be heard, okay? The right to be heard is essential component of fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed, right? The judge plays an important role in overseeing the settlement of disputes, but should be careful that efforts to further settlements do not undermine any party's rights to be heard according to the law. So when the prosecutor is trying to bring a final settlement because you might be incompetent and he's the only party on the record who has power to move the court. So now he's trying to get the judge to just bring a settlement and get you to plead or something to that degree. So, and then the judge in the favor of the settlement for the court is trying to settle, but at the same time coercing you to do something against your own will or forcing you not to be heard just to bring a settlement. So it'd be stuff like that you got to be mindful of, right? Judges should be mindful of the fact of the effect settlement discussions can have, not only on their objective and impartiality, but also on the appearance of the objective and impartiality. Despite a judge's best efforts, there may be an instance where information obtained during the settlement discussion could influence a judge's decision-making during trial. And in such instances, the judge should consider whether disqualification may be appropriate. All right, so as you go deeper into this, right, now it's going into the responsibility, right, to decide, right? So a judge shall be heard and decide matters assigned to the judge, except when disqualification is required, right? Although there are times when a disqualification is necessary to protect the rights of a litigant and preserve public confidence in the independence, integrity, and impartiality of judiciary, judges must be available to decide matters that come before the courts. Unwarranted disqualifications may bring public disfavor to the court and to the judge personally. The dignity of a court and the judge respect for fulfillment of judicial duties and proper concern for burdens that may be imposed upon the judge colleagues require that the judge do not use disqualifications to avoid cases that present difficult, controversial, or unpopular issues. Like when we come in and we stepping on our rights and we saying, hey, look, I'm the authorized representative of the estate. You know, we come in and we come from a different angle and we make it a lot difficult for him to deal with the matter at hand and to be honest and to be fair and to be impartial as far as his conduct, his code. He's supposed to have the highest intelligence and he's supposed to know the law and adhere to the law. So if you come in and you bring in facts that's undeniable before him, he has to adhere to that, or he's supposed to, right? And then the expert communications, it talks about that. We go down some on judicial statements on pending and impending cases, disqualifications. All right, so disqualifications. A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might be reasonably questioned, including but not limited to the following circumstances. A judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of a fact that are in dispute in the proceeding. A judge knows that the judge's spouse, domestic partner, a person within the third degree of relationship to either of them, or the spouse or domestic partner of such person is a party to the proceeding, or an officer, director, general partner, manager, member, or a trustee of a party, acting as a lawyer in the proceeding. A person who has more than one de minimis interest that could be substantially affected by the proceedings are likely to be material witness in the proceeding. A judge knowingly, individually, or as a fiduciary, or the judge's spouse, domestic partner, parent, or child, wherever residing, or any other member of the judge's family residing in the judge's household, has an economical interest in the subject matter in controversy, or is a party to the proceeding. The judge, while a judge or judicial candidate has made a public statement or other than in court proceeding, judicial decision, or opinion that commits or appears to commit the judge to reach a particular result or rule in a particular way in the proceeding or the controversy. The judge serves as a lawyer in the matter, representing any party to the matter while engaging in a private practice of law within a period of 7 years following the last date on which the judge represented the party. Within the preceding 3 years was associated in a private practice of law with any law firm or lawyer concurrently representing any party in a matter, provided that referral of cases when no monetary interest was retained shall not be deemed in association within the meaning of this paragraph. So like it breaks it all the way down to you. You know what I'm saying? So like because a lot of times you might be suing a company, and the company you suing, that judge that you're going before, that might be one of his children, might be a trustee or one of the little nephews or grandchildren. See what I'm saying? Because they got a lot of stuff tied up in these states. These people got businesses and stuff all throughout. You see what I'm saying? So you never know when you're trying to sue a company, and you never know when that company's connected to, because a lot of their children are becoming judges. They're becoming lawyers. A lot of them are becoming representatives of the states. And we just hanging in the hoods and chilling out while thinking we from Africa somewhere, while they acting like they just the only Americans and that they the only ones who can fill and hold office, until we start waking up and realizing that we can actually be a part of the same system, and which we are, and we should be actually involving ourselves in these political events that's going on, especially in our local counties and stuff. Right there where we live, we supposed to be really involved in the decision makings in those areas about things that's affecting us and new things that they're putting into play and stuff like that. And that's where you will see a lot of these judges, attorneys, uh, these uh, higher officials and stuff like that. When you start going to those type of events, stuff like that, and you'll start meeting these people. But let me go down. So I'm not gonna go into too much of it. I just wanted to bring it to your attention so you can go and you can read this. As you can see, it's a lot of information. All right. And then it even talks about non-public information affiliated with discriminatory organizations, participation in education, religious, charitable, fraternal, or civil organizations and activities. Because a lot of these judges and stuff, they be having, you know, they be having ties with a lot of these companies. They be doing business. They be having interest tied in through, might be a member on one of their board. They say, well, we're gonna get Judge Francis to be one of our board members. So then somebody reach out to Judge Francis about a new company that they're about to build within the community, and they wanted the judge to also be a part of this. It's going to be very good and financial investment for us all. So then the judge gets on the board. He decides to be part of their team or whatever. And now they have one of the biggest things within the city. And it'd be stuff like that that we don't even know about. And then something happened or some stuff, and then you got to go before him, but it's dealing with one of them people. You see what I'm saying? And you don't even know it. So now you're dealing with the yelling, the screaming. You wondering why he's showing all these different attributes that he shouldn't even be showing. If he a judge, he should be showing that he has discipline and that he has full control over his emotions and everything. He should be showing that he's qualified to be in that seat and hold the most calmest, steadiest temperament that you've ever seen in your life. And most of the time, we don't never see that. We see an animal coming up out of a lot of these people, man. So I just wanted to bring this to the forefront, but I ain't gonna stay here because it's a lot of information to go over. But I'm gonna let you go and do the rest of your homework for that. All right. So now I'm about to change lanes on y'all real quick. We about to jump into something else. So yeah, just remember uh, that every state has codes of judiciary conduct and in which they must follow and adhere to. And when you realize that, you'll be able to start, holding them to their duties under these titles of nobility that they hold. All right. because they're really being a public officer really is they're really subservient. But when we don't know what we're supposed to do, then we become subservient to them. The roles switch. You know what I'm saying? And it'll seem as if they're the authority over you, but in reality, they're really subservient to you as far as trying to service your needs. So, all right, so we're gonna go here, right? So, as you know, we talk about goods, we talk about what a holder is, you know. So, I like to bring accurate information to the forefront. Make sure y'all sharing, y'all liking, uh, tapping the screen for me. Subscribe to the channel if this is your first time. Uh, what we do here is we offer uh, correct information to the public. We're about building the minds of the people, showing the people the correct way of understanding the legal system, uh, contracts, agreements, understanding the proper way to conduct oneself when at sea, or what we like to call in admiralty. If you don't know what admiralty is, that's the law merchant, that's the law of the sea. Even though we're walking on actual land, the laws that govern us is the laws of the sea. That's why they say Jesus walked on water, because he was actually on the land, but when they meant he walked on water, he walked over. The laws that Jesus brought stood over the laws of the law merchants and the laws that these people were using, like what they doing today against us, how they using these code statutes and all this, taking your house. And all right, see, Jesus walked over there. He had a knowledge that was higher and above all of that. And they sought out to kill him and hated him because he was teaching people that he was God and that they were gods. See what I'm saying? So when you see it today, it seems far-fetched, but it's the same thing going on today. It's the exact same thing going on today. And it's just that people don't want to believe that God lives within you. And if you don't believe that God is the temple of your of everything you do, then that's on you if you don't know the truth. All right. And he was trying to awaken you that the true source of power is already in you. That's why you're able to be alive, because that power has empowered you and it's never left you ever since you were empowered. It's been with you, it's always with you. You wake up with that power, you go to sleep with that power, you get up and go exercise with that power. That power is the power that you need to recognize. You're recognizing everything outside of yourself, but not that power within you that's empowering you to be yourself. You got to recognize that power itself, and it's inside of you. And we're looking everywhere but within, everywhere but within, because it'll scare you half to death if you knew God was within you, huh? You'd be like, ain't no way God could be. Okay. 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 All right. Uh, Shirkism. No, no, you saying God is a man. No, I'm saying God is divinity, and that he's the source of man, and that he's the battery, that the backpack got man energized. Without God, there wouldn't be no man. You know what I'm saying? So it's like man is in God. Of course, man is being backed by the power and the will of the divine creator. That's what empowers that body to get up and move. Is backed by something. Something is giving it, just like something is giving the sun power. When you see that sun, something empowering that sun. It's getting energy from somewhere. You can't tell me it ain't getting energy from somewhere. Somewhere that sun is getting energy. Well, it might be from us, and we might not even know. We the ones empowering it. That could be true, and we might not even know it. But it's just something for you to think about. Like when you really think about it, man. Like we are a really magnificent creatures, you know, like anytime somebody can just cut you and your body can just start healing instantly. It just start healing itself. So you wonder then how do we die? That's what I say. Well, how do we die if we constantly heal? If the body constantly is trying to correct itself? It's because we don't never give it enough time to rest from all the stuff we put in it. We constantly filling it up with stuff and it don't have enough time to fight off all the stuff we putting in it. Can't heal if it's constantly being, you know, every day you just pounding all kind of stuff down into your body. And it can't fight all that stuff. It can only fight so much at a time. It's like on the overload. So yeah, I get it. Now, what I want to go into, we want to talk a little bit about common carriers. We want to talk a little bit about goods, bills of lading, consignees, holders, things like that, right? All right, so except as otherwise provided, to the extent a common carrier establishes an excuse provided by law, the common carrier must deliver goods covered by a bill of lading on demand of the consignee named in a negotiable bill or the holder of a negotiable bill for the goods when the consignee or the holder. All right, so before I go down into that, I'm gonna click on some of these words real quick. All right, so the holder. The holder means the person having possession of and a property right in a bill of lading. Consignee. Consignee means the person named in the bill of lading as the person to whom the goods are to be delivered. So the bill of lading would be like the contract or the agreement, right? And usually when it says the consignee is usually the person named in the bill that the amounts are due to. So on here it's saying the consignee is the person to whom the goods are to be delivered. The reason why it's using the word delivered because it's coming from a different aspect of explaining the same thing. So it's saying the consignee is the person to whom the goods are delivered, but the one to whom the goods are delivered is also the payee, which means the amounts are due to you. Okay, that's why every month you get a bill saying an amount due because you're the consignee. The amounts are to be delivered to you. Now, are you receiving those amounts is the problem. You might not be receiving them, but they are due to you. Okay, now check this out. Now it says, we'll read it again. So, except as to the extent a common carrier establishes an excuse provided by law, the carrier must deliver the goods covered by the bill of lading on demand of the consignee. So when you demand that the goods in the bill be delivered to you, he must deliver the goods to you, right? Now, this is what it's saying. Named in the negotiable bill, right? Or the holder of the negotiable bill for the goods when the consignee or the holder offers, number one, in good faith to satisfy the lien of the carrier on the goods, right? So when you offer to satisfy the lien to the carrier, the one who's carrying your goods, or two, has possession of the bill, and if it is negotiable bill, offers to endorse and give the bill to the carrier. Now, if your whole oh, okay, I can't make it up, man. I can't make it up. I can't make it up. People be talking, but hey, listen, I'm about showing proof, right? So it says you got possession of the bill, and if a negotiable bill, if it's a negotiable bill, offers to endorse and give the bill to the carrier, okay, agrees to sign on delivery of the goods a receipt for delivery if requested by the carrier. Hold up. Oh man. Okay. I'm gonna let that marinate for ruminate for a minute, right? Now, person to whom goods may be delivered, subject to section 8111 of this title. A common carrier may deliver goods covered by a bill of lading to a person entitled to their possession. So if you get a bill and it got your name on it or your legal name on it, and it says amount due on January the 5th, and it's coming from a common carrier, some institution that's carrying an account in your name, where amounts are due to you from that account in which they're carrying, and they're notifying you of these amounts, but somehow you misinterpret what it means because we were not taught commerce, right? We were not taught what it really means, right? So, number two, the consignee named in the negotiable bill. So, the consignee, remember, I told you earlier that the consignee means the person named in the bill of lading as the person to whom the goods are to be delivered. So, when it says right here, the consignee named in the negotiable bill, it's talking about the name, your taxpayer name, as the name written in the bill, and then it's saying how much is due to the taxpayer. All right. Now, the taxpayer is your legal account in your name, but you, the man or the woman receiving the bill, okay, you're the one that acts on the taxpayer's behalf, right? Now, check this out. A person in possession of a negotiable bill, if the goods are deliverable to the order of that person. So, wait a minute. Wait a minute. Let's stop right there. So, the consignee is the person named in the bill that is saying that the amounts in the bill are due to. Okay? Because we got to make sense. We got to make it make sense where it don't make sense. Okay? So, because like I said, as your brother, I'm all about trying to teach and show you things to help you get a better understanding so you can understand maybe what type of transactions you're in and how you should be handling these transactions, right? So now, so the person in possession of the negotiable bill, if the goods are deliverable to the order of that person. So first of all, your name got to be in the bill, first of all. And the goods in the bill got to be due to you. So if it ain't due to you, if your name ain't the name on the bill that's saying that it's due to you, then, right, you're not the consignee. But if you are the consignee, then the goods are deliverable to the order of that person. So in order for you to receive the amounts that the bill is saying, the goods must be deliverable to your order. They have to be not just due to you, but they also have to also be made payable to you in order for you to receive payment, right? Now it says the bill has been endorsed to that person or in blank by the consignee. So it's saying that the taxpayer must endorse it to you. That goes back to the UCC where it says the person endorsing the instrument it must also be a party willing to pay the instrument, or else it's not considered as an acceptance. Okay? So everything that we just read is saying that when the person who receives the bill and it got a person's name written on the bill who the amounts is due to, it's saying that that person whose name is on the front of the bill must be the person who the amounts must be made payable to. See what I'm saying? And then it says common carrier claims of title and possession. A claim by the common carrier that the carrier has title to the goods or rights to their possession is an excuse for non-delivery of the goods only if the title or the right is derived from a transfer made by the consignor or the consignee after the shipment, right? Or the carrier's lien, right? So the carrier got a lien on the goods, right? But it's saying that when you pay the goods to yourself and you claim title in the goods, non-delivery, non-payment is a false claim by the one that's carrying the goods to possession, trying to say that he got the title. But it's saying, right, it's telling you right here that that's just an excuse. You ain't got no damn title. You're in non-payment, buddy. You're non-payment, buddy. These goods are due to me, buddy. We've discovered the secret that you've been hiding from us for a very long time. That's why a contract is a simple reset of promises, because it's a simple contract. And when you understand what it is, you understand exactly what to do about it, right? If a person other than the consignee, which would be me or you, or the person in possession of the bill of lading claims title or possession of the goods, and the common carrier knows of the claim, the common carrier is required to what? To deliver the goods, okay, to any claimant until the carrier has had a reasonable time to decide the validity of the adverse claim, or to bring a civil action to require all claimants to interplead. See? See what I'm saying? See? Somebody got to make a claim. Somebody should be identifying the amounts due and who they truly belong to. And that person should be taking possession, making them payable to himself and saying, these are my goods. These are consumer goods purchased by me. And I'm claiming my title, my right to receive payment. And I make all obligations due payable to me as the lawful holder in due course. Why? Because I'm the holder in due course. Of course, you know. See, I don't know, y'all like, damn, boy, he made that thing plain and simple, didn't I, man? I made that thing plain and simple, didn't I, man? You ain't got to jump over a whole bunch of stuff to figure out some stuff, right? It says interpleader. If at least two persons claim title to possession of goods, the common carrier may bring a civil action to interplead all known claimants to the good, or require those claimants to interplead as a defense in the action brought against the carrier for non-delivery, right? Third person claim not a defense except as provided in subsection B and D and E of this section. Title or right of a third person is not a defense to an action brought by the consignee of a non-negotiable bill of lading or by the holder of a negotiable bill against the common carrier for failure to deliver the goods on demand unless enforced by legal process. So it's saying, even if they assign the contract to a third party, once you accept and demand payment of the goods due to you, right? It don't matter. It's like, get over here, boy. Where you going? Wow, get over here. Come here, boy. Where you think you going? We caught you now. Yeah, we didn't caught up with you now. We know now what it's talking about. Yeah, buddy. Yeah, buddy. I know they all like that, y'all. They all like that. We done figured it out, y'all. We done figured it out. All right, so hold up. Let me go back, y'all. Let me go back. I hope y'all enjoying the live. Make sure you tap the screen. First time on the live, make sure you subscribe to the channel, Building Better Minds, YouTube, Instagram, We're on Facebook. You get what I'm saying? So you can go to any of our platforms and you can see any of the information that we share, we upload. All right. So now, see, a general rule is that a common carrier is liable for damages to a person having title to or right to possession of goods when the common carrier delivers the goods to a person not entitled to their possession, unless the delivery is authorized under Section 811, 80, 110B, 2 or 3 of this title. The common carrier makes delivery under Section 80110B2 or 3 of this title after being requested by or for a person having title to or a right to possession of the goods not to make delivery or at the time of delivery under 80110B2 or 3 of this title, the carrier has information it is delivering the goods to a person not entitled to their possession. Effectiveness of request of information. A request for information is effective under Section 8.2 or 3 of this title only if an officer or an agent of the carrier whose actual or apparent authority includes acting on the request or information has been given the request or information, and the officer or the agent has time exercised in reasonable diligence to stop delivery of the goods, right? Failure to take a canceled bill, right? Failure to take a canceled bill. So did you know you can cancel your bills before they become due? So your bills become due like every 21 days in advance. When you receive the bill, you got the right to cancel the bill. All right. And then the bill is canceled, then they can't collect on it. All right. But a lot of people don't know that because like I say, there's a lot of stuff not being taught, except as provided in subsection B of this section. If a common carrier delivers goods for which the negotiable bill of lading has been issued without taking and canceling the bill, right? The carrier is liable for the damages for failure to deliver the goods to the person purchasing the bill for value in good faith, whether the purchase was before or after delivery. And even when the delivery was made to the person entitled to the goods, the carrier also is liable under this paragraph if part of the goods are delivered without taking and canceling the bill or plainly noting on the bill that a partial delivery was made and generally describing the goods or remaining goods kept by the carrier, right? So when you pay the bill, they're supposed to make sure that that bill is terminated, right? A common carrier is not liable for failure to deliver goods to the consignee or owner of the goods or a holder of the bill if a delivery described in subsection C of this section was compelled by legal process. The goods have been sold lawfully to satisfy the carrier's lien, or the goods have not been claimed, or the goods are perishable or hazardous. So, like I said, y'all, this like what I'm going over, what I'm reading, this is the type of stuff that I be breaking down for in more detail in my webinar this Friday, right? Where I'll be covering um, processing payments, which are state, local governments, and things like that. So, you want to actually you want to get in so you can learn certain things. This right here is just showing you uh, information that you need to know. You need to be familiar with what this is. Like, what is a purchase? Let me go back. So, a purchase includes taking by mortgage or plea. See, so when you purchase something, you either take it by mortgage or you either take it by some sort of plea. Now we know that goods are all things in action, means merchandise of personal property that has been, is being, or will be transported. So personal merchandise, bills, uh, invoices, uh, contracts, security, any type of personal property, they consider those things as goods that will be sold. All right, let me see. I don't know what just happened. Let me see. Let me look and see. Let me look in my chat, see if I ain't got anybody got any questions for the brother. Chat. Okay, how y'all doing, man? It's good to see you guys on. Uh, yeah, y'all like the video, the live so far. Like I said, man, I just went into the banking. Went from the banking, I mean, not banking, but judiciary conduct, speaking about, understanding what our judiciary officers' conduct is supposed to be and making sure that we hold them to that standard. And then now, me going into me talking about the common carriers and bills of lading and, you know, individuals' rights to receive the amounts stated in his bill every month. Understanding those rights is critical, and it's very important that you understand those rights. Um, to the haters, hello hater, hello hater. Yeah, they can hate all they want, baby, but I know brother Isaiah is woo. All right. So a negotiable bill of lading issued in a state for the transportation of goods to a place in 48 contingent states of the District of Columbia may not be issued in parts, in sets. A common carrier issuing a bill in violation of this subsection is liable for the damages for failure to deliver the goods to the purchaser of one part for value in good faith, even though the purchase occurred after the carrier delivered the goods to the holder of one or more other parts. When at least two negotiable bills of lading are issued in a state, right, for the same goods to be transported to a place in 48 contingent states or the District of Columbia, the word duplicate or another word indicating that the bill is not an original must put plainly on the face of each bill except the original. A common carrier violates this subsection is liable for damages caused by the violation of a purchase of the bill for value in good faith as an original bill, even though the purchase occurred after after the carrier delivered the goods to the holder of the original bill. Okay. Now, I'm gonna share something else with y'all real quick. Share something else with y'all. Okay. Now we want to go to the United Nations Convention of International Bills of Exchange. All right, because bills, or they are considered as bills of exchange. All right, but an actual bill of lading is something different from bill of exchange, right? Now, this convention applies to an international bill of exchange when it contains the heading International Bill of Exchange, and also contain in the text the words International Bill of Exchange. And this convention applies to international promissory notes when contained in the heading International Promissory Note, and also contain in at least text the words International Promissory Note. Now it says an international bill of exchange is a bill of exchange which specifies at least two of the following places and indicates that any two so specified are situated in different states. So a bill of exchange must at least state the place where the bill is drawn. It must either have the address where it's made out to. It must either have the place that indicates next to the signature of the drawer. Either it must have the signature, and then under his signature, his address, or the place indicated next to the name of the drawee. Or it must have either the drawee's name and address on it, or it must have a place indicated next to the name of the payee, or it must have a name, an address next to the payee's name, or the place of payment, or it must just specify the place of payment, but it got to have at least two of them on the bill. It got to have at least two addresses stated by two, either the drawer, the payee, or so forth, because that's under the convention, that's a requirement. Okay. That's very important that you remember that. Okay. Provided that either place where the bill is drawn or the place of payment is specified on the bill, and that such place is situated in a contracting state. An international promissory note is a promissory note which specifies at least two places, at least two of the following places. It indicates that any two so specified are situated in different states. The place where the note is made, the place indicated next to the signature of the maker, the place indicated next to the name of the payee, or the place of payment. Provided that the place of payment is specified on the note and that such place is situated in a contracting state. The convention does not deal with questions of sanctions that may be imposed under national law in cases where an incorrect or a false statement has been made on an instrument in respects of the place referred to in paragraph 1 and 2 of this article. However, any such sanction shall not affect the validity of the instrument or the application of the convention. So a bill of exchange is a written instrument which contains an unconditional order, right? Whereby the drawer directs the drawee to pay a definite sums of money to the payee or to his order. So a bill of exchange is an unconditional order written in writing. Exactly what it's saying that it is. It's an unconditional order written in writing, right? Which directs the drawee to pay a definite sums of money, right, to the payee or to his order. It says that it is payable on demand or at a definite time. It is dated. It is signed by the drawer. A promissory note is a written instrument which contains an unconditional promise whereby the maker undertakes to pay a definite sums of money to the payee, right? Or to his order, right? It is payable on demand or at a definite time. It is dated, right? It is signed by the maker. This right here is so powerful, man. I can't even tell you how powerful that right there. That's powerful. If you don't understand it, I'm sorry. You just got to learn. You know what I'm saying? But this is very powerful right here. You know, when I first read this, I didn't know what the hell it was talking about. But hey, listen, I'm gonna read it again for you, right? All right. So a bill of exchange is a written instrument which contains an unconditional order whereby the drawer directs the drawee to pay a definite sums of money to the payee or to his order. It is payable on demand, right? Or at a definite time. It is dated and it is signed by the drawer. Okay? And a promissory note is a written instrument which contains an unconditional promise whereby the maker undertakes to pay a definite sums of money to the payee, right? Or to his order. It is payable on demand, right? So it's payable on demand and is dated, is signed by the maker. Now it says in the interpretation of the convention, regard is to be had to the international characters and to the needs to promote uniformity in its application and to observance of good faith in international transactions. Now it says a bill means an international bill of exchange governed by this convention. All right. A note means a international promissory note governed by this convention. An instrument means a bill or a note. Okay. Drawer means the person on whom the bill is drawn and who has not accepted it. Wait a minute. Wait a minute. Wait a minute. What? I thought the drawee was the bank. I thought the drawee was the bank. I thought the drawee was the bank. Something to think about. All right, so the drawee means the person on whom the bill is drawn and who has not accepted it. The payee means the person in whose favor the drawer, right, directs payment to be made or to whom the maker promises to pay, right? And then the holder means the person in possession of an instrument in accordance with Article 15. Protected holder means a holder who meets the requirements of Article 29. And the guarantor means the person who undertakes an obligation of guarantee under Article 46, whether governed by paragraph 4B, guaranteed, or paragraph 4C, avail of Article 47. Party means a person who has signed an instrument as the drawer, as the maker, as the acceptor, as the endorser, or the grantor. Maturity means the time of payment referred to in paragraph 6 and 7 of Article 9. And a signature means a handwritten signature. And its facsimile or an equivalent authentication effected by any other means. Forged, signed, includes a signature by the wrongful use of such means. Money or currency includes a monetary unit of account. See? So all this stuff was talking about holders, instruments, negotiable instruments, signers, parties. And then at the very bottom, it says money or currency includes a monetary unit of account, which is established by an intergovernmental institution or by agreement between two or more states, provided that the convention shall apply without prejudice to the rules of the intergovernmental institution or to the stipulation of the agreement. For the purposes of the convention, a person is considered to have knowledge of a fact if he has actual knowledge of that fact or could have had been aware of its existence. The sums payable, right? So when you receive an instrument, this is what it's saying. The sums payable by an instrument is deemed to be the definite sums, although the instrument states that it is to be paid. So when you receive any instrument, a mortgage, a lease, or any instrument, even though it says the sums payable by an instrument is deemed the definite sums. So when you receive the instrument, if it's saying you've been financed at 50,000, that's the definite amount that you have right there at that time. It's 50,000 in your hand, even though it's saying that that's the amount that you owe to pay the loan on. Even though it's saying it's what you owe, it's still the amount that you actually hold at that moment. Because you can't owe something without being in possession of it. So even though the instrument comes to you saying this is what you owe, that's only because that's what you're receiving. You can only owe what you receive. So if you're unaware how to ascertain that value that the instrument has just given you, you're going to default. You're going to automatically default because you don't understand that the amount that they're saying you owe is the amount that you have possession of, and you don't know how to use it. Okay? So I'm just trying to bring it to your awareness so you can see things clearly, because the truth is out here for you. You just have to know how to seek it out, right? Now, it says the sums payable by an instrument is deemed to be a definite sums, although the instrument states that it is to be paid with interest by installments at successive dates, with a stipulation in the instrument that upon default in payment of the instrument, of any installment, the unpaid balance becomes due, according to the rate of the exchange indicated in the instrument, or to be determined as directed by the instrument, or in currency or other currency in which the sums is expressed in the instrument. So it's saying, like, look, man, I can't make this up, man. You know how powerful this is right here? Do y'all understand? If you understand what you're reading on the screen, do you know how powerful this is? Do you understand what this is telling you? Hold up. I don't think you get it. Because I'd be jumping out my seat right now if I understood what this meant. You know what I'm saying? Like, you'd be jumping out your seat if you truly understood what this is telling you. It's telling you that the sums payable by an instrument is deemed to be the definite sums, the amount due. On the instrument is the definite amount of the instrument. Although the instrument states that it is to be paid, even though it's saying that that's the amount you owe, that's actually the amount that you actually applied for. When you applied for the loan, you actually receive the actual amount in the instrument, even though it's saying that that's the amount that you owe on the instrument. So if you don't understand what it's saying and you don't understand what's going on, guess what you're going to do? You ain't going to make payment because you don't understand how, even though it states that it's with interest. See, by installments at successive dates. So it can even say that you owe these amounts and you owe your first installment is on this date and all. Even though it's saying all of that, that is still what you got to realize is the amount that is saying you owe, even though it's saying these are the amounts you owe, those are the amounts that you actually have the rights to use right then and there. You can use those amounts since you owe them. You see what I'm saying? So it's just all about changing the way you think, the way you see something, or you've been taught. We've been taught things that are not to our benefit, right? It says if there's a discrepancy between the sums expressed in words and the sums expressed in figures, the sums payable by the instrument is the sums expressed in words. So the instrument, if the instrument is expressing something is due, and somebody writes words on how that amount should be paid, then the instrument is payable by what's expressed in words written on the instrument. If the sum is expressed more than once in words and there is a discrepancy, the sums payable in a smaller sum, the same rule applies. If the sums expressed more than once in figures only, there is a discrepancy. If the sums is expressed in currency having the same description as that of the last one or one other state, then the state where the payment is to be made, the indication in the instrument and specified currency is not identified as the currency of the particular state. The currency is to be considered as the currency of the state where the payment is to be made. If the instrument states that the sums is to be paid with interest without specifying the date from which the interest is to run, interest runs from the date of the instrument. And the stipulation stating that the sums is to be paid with interest is deemed not to have been written on the instrument unless it indicates the rate at which the interest is to be paid. So all these, and when you're going out and you enter into these agreements, you're receiving instruments that you're supposed to be paid to you as the party entitled to it. A rate of interest is to be paid may be expressed either as a definite rate or as a variable rate. For variable rates to qualify for this purpose, it must vary in relation to one or more references rates of interest in accordance with the provisions stipulated in the instrument. And each such reference rate must be published and otherwise available to the public and not be subject, right? So all this is dealing with the instrument, right? Now it talks about Article 9. An instrument is deemed to be payable on demand if it states that it is payable at sight or on demand or on presentment, right? Or if it contains words of similar import, or if no time of payment is expressed, right? An instrument payable at a definite time, which is accepted or endorsed or guaranteed after maturity, is an instrument payable on demand as regards the acceptor, the endorser, or the guarantor, right? An instrument is deemed to be payable at a definite time if it states that it is payable on a stated date or at a fixed period after the stated date or at a fixed period after the date of the instrument at a fixed period after sight by installments at successive dates or by installments at successive dates with the stipulations in the instrument that upon default in payment of the installment, the unpaid balance becomes due. The time of payment of the instrument payable at a fixed period after the date is determined by reference to the date of the instrument. The time of payment of a bill payable after the fixed period after the site is determined by the date of acceptance. Or if the bill is dishonored by non-acceptance, by the date of protest. Or if protest is dispensed with by the date of dishonor. The time of payment of an instrument payable on demand is the date on which the instrument is presented for payment. The time of payment of a note payable at a fixed period after sight is determined by the date of the visa signed by the maker on the note, or if his visa is refused, by the date of presentment. If an instrument is drawn or made payable 1 or more months after the stated date or after the date of the instrument or after sight, the instrument is payable on the corresponding date of the month when the payment must be made. If therefore, if there is no corresponding date, the instrument is payable on the last date of that month. Then it says a bill may be drawn by 2 or more drawers, payable to 2 or more payees. And then it says a note may be made by 2 or more makers, right? And payable to 2 or more payees. If an instrument is payable to 2 or more payees, in an alternative, it is payable to any one of them, and any one of them in possession of the instrument may exercise the rights of a holder. In many other cases, the instrument is payable to all of them, and the rights of the holder may be exercised only by all of them. So, man, listen, I can't make this up, man. It's pretty much telling you that you are the one entitled to claim the instrument. If it's due to you, it got your name on it, it's your instrument, it's your value, it's your right to claim it, to take possession of it. It's yours, right? A bill may be drawn, a bill may be drawn by the drawer on himself, payable to his order. Need I say more? Need I say more? Come on, man. An incomplete instrument which satisfies the requirements set out in paragraph 1 of Article 1 and bears the signature of the drawer or the acceptance of the drawee, or which satisfies the requirements set out in paragraph 2 of Article 1 and paragraph 2D of Article 3, but which lacks other elements pertaining to one or more of the requirements set out in Article 2 and 3 may be completed and the instrument so completed is effective as a bill or a note. If such an instrument is complete without authority or otherwise than in accordance with the authority given, a party who signed the instrument before the completion may invoke such lack of authority as a defense against the holder who had knowledge of such lack of authority when he became the holder. A party who signs an instrument after completion is liable according to the terms of the instrument so completed. Right? An instrument is transferred by endorsement and delivery of the instrument by the endorser to the endorsee. So remember, I told you a sale is a transfer of the document from one person to the next. So when you endorse an instrument and deliver it, that's considered as a transfer. And by mere delivery of the instrument, if the last endorsement is in blank, right? So if the last endorsement on the instrument is signed in blank, you could just deliver the document. An endorsement must be written on the instrument or on a slip affixed thereto and a lodge. It must be signed. So it's telling you that an endorsement goes on the instrument or it goes on another instrument that's attached to the instrument. An endorsement may be in blank, meaning just a signature alone, that is by a signature alone, or by a signature accompanied by a statement to the effect that the instrument is payable to the person in possession of it. Now, I didn't say it. I didn't say it, y'all. That's what it said. It said that it's either signed in blank or either got a statement saying that it's payable to the person who's in possession. I'm going to let you marinate and think who that person might be. All right. Now it says a special that is by signature accompanied by indication of the person to whom the instrument is payable. A signature alone, other than that of the drawer E, is an endorsement only if it's placed on the back of the instrument. Need I say more? Need I say more? All right. A person is a holder if he is the payee in possession of the instrument. Now, if he is the payee in possession of the instrument. So if you're able to recognize yourself as payee in possession of an instrument that's payable to you, you're able to become a holder. Oh, wow, that's a beautiful thing right there. Okay. In possession of an instrument which has been endorsed to him, or which the last endorsement in blank, and on which there appears an uninterrupted series of endorsements, even if the endorsement was forged or was signed by an agent without authority. If an endorsement in blank is followed by another endorsement, the person who signed this last endorsement is deemed to be the endorser by the endorsement in blank. So if you sign in blank and somebody sign and give instructions over your signature, you become bound as the endorser because you left it as a blank endorsement. A person is not prevented from being a holder by the fact that the instrument was obtained by him or any previous holder under circumstances, including incapacity or fraud, duress, or mistake of any kind that would give rise to a claim to or a defense against liability on the instrument. The holder of an instrument on which the last endorsement in blank made or the endorse it either by an endorsement in blank or by a special endorsement. Convert the blank endorsement into a special endorsement by indicating the endorsement that the instrument is payable to himself or to some other specified person. So what this is saying, you could receive a loan, and that loan could be issued for your personal family and household benefit. And then you can give a blank endorsement and transfer that loan to a holder, and then the holder can say pay to them over your signature, and then now the instrument becomes payable and collectible by them because you never took possession of the instrument, right? So that's what it's talking about, right? Now, transfer the instrument in accordance with subparagraph B of this title. If the drawer or the maker has inserted in the instrument such words as not negotiable, not transferable, not to order, pay only, or words of similar import, the instrument may not be transferred except for the purposes of collection. And any endorsement, even if it does not contain the words authorizing the endorsee to collect the instrument, right, is deemed to be an endorsement for collections, right? So if you write non-negotiable, non-transferable, not to order, pay only, or words of similar import for payment only, and if the endorsement contains the words not negotiable, not transferable, not to the order, pay only, or words of similar import, the instrument may not be transferred further, except for the purposes of collection. And any subsequent endorsement, even if it does not contain the words authorizing the endorsee to collect the instrument, is deemed to be an endorsement for collection. So even if you don't endorse it for collection, if you say non-transferable, non-negotiable, for collection only, and you endorse it back, they got to collect that amount. You see what I'm saying? An endorsement must be unconditional. A conditional endorsement transfers the instrument whether or not the condition is fulfilled. The condition is effective as to those parties and transferees who are subsequent to the endorsees. An endorsement in respect of part of a sum's due under the instrument is effective as the endorsement. If there are two or more endorsements, it is presumed, unless the contrary is proven, that each endorsement was made in the order in which it appears on the instrument. If an endorsement contains the words for collection, for deposit, value in collection, by procurement, pay to any bank, or words of similar import authorizing the endorsee to collect the instrument, the endorsee is a holder who may exercise all rights arising out of the instrument, may endorse the instrument only for the purposes of collection, is subject only to the claims and the defenses which may be set up against the endorser. The endorser for collection is not liable on the instrument to any subsequent holder. Okay? Well, I'm gonna stop right there now. I just gave y'all the juice. All right, so if you want to know more about negotiable instruments, you want to know more about your rights in reference to the contracts and things like that, go read that International Bill of Exchange Act. Take your time, read through it thoroughly, look up any phrases, any words that you don't understand. Make sure that you extract from that as much as you can to get as much interpretation and understanding for your own benefit, because if you truly go in there and you get an understanding, it can change the way and how you operate and the way that you do things in reference to understanding the agreements, understanding billing errors, understanding disputes, understanding everything, because everything is all it's all tied together. And it's really not many different ways to understand it. Once you understand the core principles of everything that's going on, it makes all the sense in the world why you should do certain specific things. All right. And with that said, man, I'm gonna go ahead and get up out of here. But like I said, y'all stay tuned and remember this Friday, I do have a webinar going into some very pertinent fire information that's going to do it can't do nothing but win. That's all you can do is win. So if you're looking to win, you're looking to learn more, you're looking to grow in this what we call I like to call it this think tank. Because it's like a think tank. You gotta constantly be thinking and trying to know what rights you have to stand in the right capacity when you're dealing with a lot of these different agencies and stuff. So study, study, study to show yourself approved. Make sure that you cross your T's, you dot your I's. Make sure you follow people that are providing you with source information, showing you where the information is located. Don't just listen to a person just because they're talking and they sound good. Make sure that they back up the information with resources and stuff so that you can see it for yourself. And with that said, I thank you for your time. Thank you for being here. And like I said, y'all go to buildingbetterminds.info, go to our current event page and check us out, man. We got many different things that we offer. If you like to be a member, if you like to join us and, interact with us, man, you're more than welcome. Peace and love. Y'all have a blessed and wonderful day. I'll see y'all a little bit later.